I think we're ready to go then. Thanks, TJ. Good afternoon. My name is Benno Kimmelman, and on behalf of myself and Edna Sussman, we welcome you to the afternoon session of the Fordham Conference. This afternoon, our second panel is going to be different than any other panel we've done before in the 5 years that we've put on the conference, and that is we're going to have a mock Supreme Court argument on a topic that has really become the focal point for international arbitration practitioners, certainly in the United States and even around the world. It's the question of whether Section 1782 of the U.S. Code applies to private international commercial arbitrations. Many of us have debated this issue back and forth for many years now, but the flurry of decisions from the U.S. Courts of Appeals over the last few months has just reiterated the split in the circuits that exists in the United States today. And so, you know, which court you walk into in the United States will very much influence how this section is interpreted in the context of international arbitrations. So we asked the question, what will the Supreme Court do? And we thought one way to look at that would be to put together a tribunal of very, very experienced Supreme Court practitioners and also a teacher of international arbitration and litigation. And you can see on the next slide that our panel consists of Paul Clement, Nicole Saharsky, and Pamela Bookman. We have a former U.S. Solicitor General, a former deputy, and a former clerk for Justice Ginsburg. And so they will be hearing argument this afternoon from very talented advocates. And again, we made a little modification from what the Supreme Court might see. We put together a team of appellate Supreme Court practitioners together with international arbitration practitioners on the theory that that might be a really interesting way to present the issues to us. And so you will hear each of the counsel introduce themselves and make their arguments. After the arguments are completed, we will hear from the panel with their thoughts on which points they think may be of most interest or most persuasive to the Supreme Court if and when this issue finds its way to the court's docket. And lastly, we hope that that there'll be some time for questions from the audience. The CLE materials were provided by link last night. The CLE code appeared on the first slide, and it is ATP 20. Again, ATP 20. I now turn the program over to the presiding Justice, Mr. Clement.
Thank you, Benno. And without further ado, I'd like to call the case and ask counsel for petitioner to lead us off.
Mr. Chief Justice, and may it please the court, Kwaku Akoa for the petitioner. The court below adopted a categorical rule, specifically that no private commercial arbitration may ever qualify as, quote, a foreign or international tribunal, unquote, within the meaning of Section 1782. Under that erroneous construction, a district court would have no authority to grant a request for discovery aid, even that came directly from the arbitrators themselves. Worse still, because Section 1781 uses the same statutory phrase, foreign or international tribunal. That construction would rob the Department of State of statutory authority even to transmit a request from the panel to a recipient in the United States. This is no way for a court in a pro-arbitration jurisdiction like the United States to interpret the law. And it is no way to interpret Section 1782, which was adopted amid the explosive growth of international commerce and with it international litigation in the 1950s and 60s, to expand dramatically the scope for a district court to aid the production of evidence, to aid in the resolution of such proceedings.
Counsel, can we just clear out some low-hanging fruit here and get one thing just, I think this is non-controversial, but you would concede, wouldn't you, that before the 1966, I think it is, amendments, or 64 amendments, that you couldn't get this kind of discovery in an arbitration proceeding, right?
That's right. Before the 1964 proceeding, clearly there had to be a judicial proceeding in order for a district court to grant aid. But that's exactly what Congress changed in the 64 amendment.
Sure, but Congress pretty clearly was interested in expanding from sort of core foreign judicial proceedings to perhaps some international tribunals and some, they're trying to capture civil law countries and, and other things. So that you would concede, wouldn't you, that that's the principal reason that Congress extended the statute to so-called international tribunals?
I'm not sure what the principal reason was. They were met with a real sea change in the volume and importance of international disputes, and sought to meet that as part of what in this court's decision in Intel described as a program of expansion going all the way back to the 1850s of efforts to make the district courts amenable to the provision of aid. So yes, I think they had in mind certainly judicial proceedings abroad, maybe also what they call quasi-judicial proceedings, agency adjudications, but the statutory language isn't so limited. Tribunal, as Professor Smith explained in his law review article, was chosen for a reason. It was chosen to encompass all adjudicatory bodies, including specifically, Professor Smith says, arbitrations. And this court in Intel looked to exactly that language in helping to explain why the European Commission, even when it acts as an investigatory body, not adjudicating anything, is a tribunal.
Surely you're not telling us to interpret an act of Congress based on a law review article, are you?
Not based on a law review article. I mean, I think what we're primarily working off the language tribunal, which the Supreme Court itself has understood to encompass international arbitrations, but also that as with the APA, when Congress borrows dramatically from the work of drafters, and then the court has looked to the Attorney General manual on the APA as a significant guide to the statute's meaning. Here too, just as the court did in Intel, it looked to what did the committee do? It's not just a law review article. It's right, the work of the reporter of the commission explaining what the commission had in mind and what it sent to Congress and what Congress adopted.
Right, but in Intel we had it was clearly a governmental tribunal. It was a public tribunal.
Oh, sure. In Intel there was a different kind of body at work, and as I noted, it in fact wasn't actually engaged in adjudication there. So to my mind, the holding of Intel demonstrates the breadth of what Congress had in mind when it adopted the phrase foreign or international tribunal. But I think the point is that when this court looked to that law review article, it wasn't just a law review article. It was quoted 7 times, and there was a reason for that. It's because it was quite an illustrative statement of what the drafters of the work that Congress commissioned. They said, go and think about what rules we ought to adopt. They got the commission's work back. They adopted it wholesale, and the court thought that, and I think correctly, that the work of the reporter of that commission in explaining what the commission's thought process had been was important to the court's understanding of how to read the statute that Congress adopted in light of that work. So I don't think there's anything revolutionary about that.
What evidence do we have that Congress was concerned about private arbitrations? I just find it hard to believe that Congress intended to include private arbitrations, because I just don't think there were a lot of private international arbitrations in the 1960s.
Well, as a matter of fact, the New York Convention had just been negotiated and adopted and put out for ratification in 1958, and so you have a whole rise of countries adopting the New York Convention, and the U.S. considering the adoption of the New York Convention, which eventually occurred in 1970. So actually, I don't think it's a stretch at all to think that in that context, when Congress was started to think about, well, what's the next step that we need to take in helping the district courts assist in the conduct of international dispute resolution, that they had in mind not just court proceedings, and not just quasi-court agency proceedings, but also private commercial arbitrations,
But
which
to
are
the extent that they were thinking of 1782 as like setting an example for the world that they hoped that other countries would follow, that other countries haven't followed, but that they hoped at the time they might follow, right? How does that fit in with this sort of, the world adopting the New York Convention, right? The New York Convention getting adopted in a variety of countries around the world was not accompanied by or even, conceived of as being tied to something like 1782. And in fact, I mean, the attachment of the New York Convention to US style discovery from an international perspective is not necessarily an appealing one.
But a couple of points here, Your Honor. One, I don't think Congress was purely thinking about the New York Convention and what other countries ought to do. Congress had been acting in that field at that time for over a century to say that the district courts ought in various ways, and the move was to expand, ought to provide aid to foreign proceedings, and Congress kept changing and expanding the range. I think in terms of the U.S. style discovery, and I'm glad to get to this early because I think that's a significant part of what the courts that have adopted respondents' view have been reacting to, is saying U.S. style discovery has no place in arbitration. I don't think we're talking about U.S. style discovery. I think we're talking about a process whereby participants in an international tribunal or the tribunal itself can go to district court and say, here's what would further this proceeding. The district court can, in light of that proceeding, the proceeding that's the foreign or international proceeding, can say this is fit for that occasion or not fit for that occasion. It can narrow it, it can reject it outright. So I think it's a misnomer to suggest that what we're looking at here and what we're asking for is US style discovery. What we're asking for is a non-categorical rule, one that allows foreign or international tribunals and participants, interested persons in them, to ask a district court for help. And then of course, there's a second check. It's not just the district court. The tribunal itself will have its opportunity to say whether it will receive the information at all, what it will do with it. And to the extent it sends a signal that it's not interested, that's something that the district court should factor in under intel. So
perhaps I'm interested in why, as you said in your opening remarks, you think that your version of 1782 is the more pro-arbitration. In other FAA cases, we've been really excited about distinguishing between arbitration and litigation, and in part not making arbitration sort of look like litigation, and that line I think speaks towards to differentiating those in this regard. Why is this the pro-arbitration tack?
Because that's the position that allows an arbitration panel abroad or an international arbitration panel to get the information that it may think is necessary to a proper resolution of the dispute before it. Again, this is not requiring the district court to do anything. It's not requiring the panel to accept anything. It is saying there's no categorical bar on asking a district
counsel,
court.
I have sort of a related but almost more fundamental problem, which is we know exactly what Congress would do to facilitate arbitrators getting access to information, because they did it in 9 U.S.C. Section 7. And they said, we'll take this stuff when the arbitrators themselves ask for it, not when just one of the parties asks for it on the off chance that the arbitrators might be interested. So what possible sense does it make to say that we're going to have a sort of a more permissive rule when it comes to foreign arbitrations than we do to domestic arbitrations when Congress focused right on this problem in 9 U.S.C. Section 7?
I mean, actually, I think it's quite sensible to say that, for example, a tribunal seated in Tokyo, as in the Mitsubishi case that we cite in our outline, need not itself go to a United States district court. That's going to be an unusual and perhaps uncomfortable exercise for an arbitration panel, particularly one in another country. It makes sense to have the party or the interested person take on that burden. And of course, as I mentioned, the the tribunal abroad can say, I'm not interested in that, and that would be a significant factor under intel for the district court to consider. But in terms of where to put the burden, I think it's quite a different matter than if there's an arbitration panel seated in Manhattan and asking them to go downtown to the Southern District of New York for aid, as opposed to a panel seated on the other side of the world and saying, if you want this, do it yourself. That seems to impose quite a burden on the arbitrators.
But I think that gets back to Justice Bookman's question about whether your position is really pro-arbitration. I mean, it's one thing to say the arbitrators are in control, and if they really need information, they can ask for help. It's another thing to let a party to an arbitration go run to a court and get the information. I mean, it's a weird pro-arbitration rule that says that a party to an arbitration can run to court.
Well, I actually, both sides agree that in some circumstances, a party to an arbitration can run to court. My friends say that it's only some arbitrations, investor treaty arbitrations, which are state-sponsored as they frame it, which may go to a district court in the United States for aid. So we're already across the Rubicon there. The only question is whether it is those arbitrations styled as private and commercial, which may like the investor treaty-based arbitrations also take advantage of the 1782 mechanism. So again, I don't think this is a radical or radical position here. It is just to extend to private commercial arbitration the same possibility of aid from a district court.
I just worry about it leading to lots of fishing expeditions. I mean, it's really interesting to me that the statute's been in place since the 1960s, but there's this huge uptick, it seems like, just in the past few years with parties trying to use this to what seems like perhaps fishing expeditions.
And I think that's a place where the sound judgment of the district courts is critical to the proper functioning. I'm not advocating here for open the floodgates to U.S. style discovery as a mode of promoting arbitration. I would say that would be inappropriate, and I trust the respondents would agree.
But you're burdening district courts. You're going to burden the district courts with all of these requests.
There will be requests, and the district courts will manage them in light of the intel factors. I don't think that what we're going to experience is a giant flood, in particular because you have this conversation between the parties to the arbitration, the tribunal, and the parties to the arbitration, the tribunal, and the district court, when which each of them has something to say about whether it's appropriate in a particular circumstance to provide a particular kind of discovery aid. So, I don't think there's a real floodgates concern. Certainly some district courts will have to exercise judgment, but they're perfectly capable of doing so in light of the particular needs of arbitration generally, and then also of the particular proceedings that they are being asked to aid. I see that my time is coming to a close here. Unless there are further questions, I'll reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll now hear from counsel for the amici.
Thank you, Mr. Chief Justice. May it please the court, I'm Kalima Awad here on behalf of the amicus professors in support of Petitioner. Applying Section 1782 to commercial arbitration serves a dual purpose. Number one, it furthers the policy aim of the statute. And number two, it harmonizes the statute across international arbitration. So I'll take each of these in turn. First, applying Section 1782 to international commercial arbitration furthers the statute's policy aim of providing efficient assistance to participants in international litigation. Now, respondents amicus does not dispute that this is the premise of the statute, or that applying it to international commercial arbitration does in fact provide assistance to international litigants and tribunals in obtaining evidence found in the US that they may not get otherwise. Nor does respondents amicus challenge that Section 1782 evidence can be outcome determinative and explosive. And to that, I refer you to our papers with respect to the Chevron v. Ecuador Section 1782 applications, which uncovered a tangled web of fraud and corruption and bribery that were critical to the different foreign proceedings that were ongoing. And it goes to the point that question that Justice Bookman had made earlier about what interests are served and whether justice is served in that respect. And we submit that it is, and it allows the tribunal to actually make an informed decision and to try to reach the best result and the most fair result that it can.
Can I just ask you a question about this? I understand, some of the benefits that you're pointing out, like in the abstract, but I do still have this concern about treating foreign arbitrations, allowing even more discovery in foreign arbitrations than what would be allowed for domestic arbitrations. And that just seems like a real mismatch, because it seems like what the U.S. court should be giving more protection to or more discovery for the domestic arbitrations.
So I would say that this is a policy decision that obviously Congress has made. It's specifically by enacting that statute. And so if Congress wants to extend those same tools and mechanisms and make them available to domestic arbitrations, it can do so. The fact that it hasn't done so shouldn't be used to punish international arbitration.
But isn't the argument that it in fact hasn't done so because the tribunal is not supposed to apply to either domestic or international? I mean, how does that answer? How is that determined which Congress has done?
I mean, if you look at what it takes us back to the textual interpretation of what tribunal is, and I'll defer back to the petitioner's view that tribunal does encompass any adjudicative body that makes an adjudicatory decision. The fact, that Congress has made a decision to extend and to allow foreign-seated tribunals and arbitral tribunals, we would say can be foreign-seated, can even be domestic-seated, U.S.-seated, but also have an international component, which makes them non-domestic under the New York Convention, that those tribunals should be allowed to have aid and assistance here in the U.S. It doesn't conflict with whatever regime the Congress has wanted to make available to domestic arbitration. They're just different mechanisms, ways in which arbitral parties can resort and get assistance from the court. Courts are often lending their coercive powers and their assistance to tribunals all the time, whether it's compelling arbitration or enforcing arbitral awards. So there's always sort of a relationship between the two. They're not operating in silos, wholly independent from each other.
And I just have a question about international comity, because I think you just assume that having this discovery is like just a pure good. But if I were a judge on an international tribunal or an international court or an international arbitration, and one of the parties went running to a court in the U.S., I'd be pretty upset about that. It kind of seems to me that there's a concern perhaps that we should have about U.S. courts interfering in foreign proceedings.
Well, I mean, it goes back to the point about both the discretion of the courts themselves, but certainly the receptivity of the tribunal and whether or not it wants to allow that evidence to come in. Some tribunals might be more proactive and already say up front that they don't, that they expect all the discovery to happen within the context of the arbitration. But what I would point out is the fact that Section 1782 is really in its application directed to third parties and to getting that information from parties that are not within the jurisdiction of the tribunal, who is the arbitral tribunal, who's hearing the dispute. And so
but counsel, I guess I'm still having trouble because, I mean, both you and the petitioner you're supporting sort of seem to say, well, the district courts are going to exercise their discretion and they're usually only going to facilitate these requests when the tribunal actually wants it. And we have a model for a statute that would allow parties to get information only when the tribunal affirmatively wants it. And that's 9 U.S.C. Section 7. So it just seems hard to believe both that we want sort of more involvement in international arbitrations, or that it seems to me maybe powerful evidence that Congress wasn't thinking about arbitration at all in 1782. So could you respond to those concerns?
Well, I think that I think that to the extent that Congress wants to allow the tribunal to allow the parties, it made a conscious decision, right, to go from a prior system where it was for the tribunals to do that, and then to empower the parties to be able to be the ones to go and look for that evidence, interested parties, not even parties to the arbitration, but interested parties. And again, it doesn't even necessarily require an arbitration or foreign proceeding to be to be ongoing, but just to be contemplated. So actually the reach of that statute is...
Can I stop you there though? Because that's something that I think you're absolutely right, but that's kind of even more frightening, isn't it? Like somebody could walk into federal court and say, hey, there's no foreign arbitration pending at all. but there could be one, depending on what I turn up. So could you facilitate my 1782 request? I mean, that seems pretty extraordinary.
But that's precisely what Congress did, and district courts are perfectly equipped to deal with these kinds of requests. I mean, anyone can walk into court and ask for anything, right? And district courts are there to be the ones, sort of the gatekeepers for various things. And so that's precisely why the Supreme Court actually issued, you know, in the Intel factors, had issued some guidance for the district courts as to how to deal with these kinds of questions and look at the nature of the proceedings and look at whether it's intended to circumvent, you know, foreign fact-gathering proceedings.
Is that work? I mean, you keep referring to that. Is that working? I mean, it does seem, you know, as we've discussed, is that 1782 applications are increasing a lot. The Chevron example, it seems to me, is not entirely useful insofar as it produced a ton of this. I mean, if we're worried about district courts being inundated by these kinds of applications, the Chevron case makes me more worried about that kind of inundation.
Well, there's a policy, there's a balancing act, right, to be done in some respects. I mean, the Chevron case was massive because it was a massive kind of unprecedented fraud that uncovered a lot of evidence. I don't think it's probably one in a lifetime kind of case. And so yes, perhaps in that instance, there was just, you know, I forget the number of Section 1782 applications that were filed in support of that arbitration and the foreign proceedings. There were criminal proceedings at stake as well. But I think on a general basis, I don't know that if you were to take out and I haven't done that, maybe that's something to look into, but if you were to take out all the Chevron applications that were Section 1782 applications, is there really that huge of an uptick that it should be that concerning that we're flooding the district courts with these kinds of requests when it's intended to be there in order to support and lend support to foreign tribunals and foreign litigants who may not otherwise have access to that information because it's found in the U.S. and they can't reach those third parties to get that information without the district court support.
But just to be clear, if it were found in any other country and the parties wanted it, they couldn't get it, right?
Well, one of the policy aims, the second policy aim of the statute was to try to encourage other jurisdictions to have those kinds of similar statutes in place so that you could go to another country and get that kind of information if it were found elsewhere. I don't, you know, I haven't done a survey of what these other countries have done. I think there are a couple of countries that have some, like the UK, that has some kind of mechanism where the courts can help you get evidence when that's found in country. But I don't think, it's not my understanding that, you know, any other country has followed suit in terms of adopting such a broad tool that's available to international tribunals.
So it seems clear that Congress was intending to do some kind of expansion in 1964, and that's why I put in this foreign or international tribunal language. But what do you think is the best evidence that Congress really intended it to be private foreign arbitral tribunals private foreign arbitrations as opposed to like state-sponsored foreign arbitral tribunals? I'm just trying to figure, like, what's your best argument for that, or things that you think makes the absolute most sense to do it that way?
Well, maybe it's sort of a two-part answer. The first is they don't draw a distinction between treaty and commercial tribunals. That's something that's come up in some of the circuit decisions that have refused to extend Section 1782 to treaty tribunals. So I think there's a statutory argument there that it's not actually in the text, a textual argument, sorry. But then the second one is I would challenge whether or not treaty tribunals are the only ones who are state-sponsored, because in fact, commercial arbitration is also state-sponsored in the sense that it cannot, I mean, the whole arbitral system is dependent on state support. It's dependent on international treaties like the New York Convention, enforcing arbitral awards and enforcing arbitral agreements. It relies on national legislation giving effect to arbitration, the whole arbitral system, and lending the court support in a pro-arbitration jurisdiction, lending the court's support to arbitration in order for it to succeed. So I would argue, and in fact the restatement says the same in the reporter's notes, that actually commercial arbitration is just as sponsored by the state as treaty tribunals are for that reason. And I think I'm out of time, so unless the court has more questions for me, I will cede the floor to respondents.
Thank you, counsel, and we will now hear argument from the respondents.
Mr. Chief Justice, and may it please the court, Martine Sacconi for the respondents. As this court has repeatedly explained, the plainness or ambiguity of a statutory language is determined not only by reference to the language itself or by dictionary definitions of the component words, but also by the specific context in which that language is used and the broader context of the statute as a whole. Applying that direction here leads to one conclusion. Foreign or international tribunal, as used in Section 1782, is limited to tribunals exercising government-conferred authority and excludes private commercial arbitrations. Specifically, the two other uses of an identical or nearly identical phrase within Section 1782A make clear Congress's intent. And because it is apparent from the statutory context that foreign or international tribunal does not cover private arbitrations, this court need not proceed any further in its analysis. If
Okay,
this
so
court,
to make sure I understand your argument, you basically admit that foreign or international tribunal is ambiguous and can be broad, right? I think, but then I think your argument has to do with the letter rogatory and the procedural provision that you say can only apply in state-sponsored tribunal. Can you just explain that to me, that context-based argument?
yes, Your Honor, we don't think that the language is ambiguous. We think that when read in context, when read in the context of the broader statutory provision, the language is clear in itself. So we disagree. I would disagree with the premise that it's ambiguous to the extent that you would then need to look to legislative history. Having said that, of course, if I think the language is at worst ambiguous from our perspective, and in that case, then you look to legislative history and the intent of Congress becomes even more clear.
Legislative history, just to be
Understood.
clear. I was just trying to say that I thought foreign or international tribunal just all alone isn't all that clear, but that you seem to be telling me that other stuff in this same section A about the letters rogatory and the procedures makes it more clear. So I guess I wanted to hear more about those letters rogatory and procedures.
Yes, that's right, Your Honor. So there's three references to either foreign or international tribunal or a very similar phrase within Section 1782 itself. The first is in the first sentence, which is the contested use. The second sentence, which is, as Your Honor pointed out, refers to letters rogatory. And if you want to look to the language itself, it's at page 1 of the record. So the second sentence reads, the order may be made pursuant to a letter rogatory issued or a request made by a foreign or international tribunal or upon the application of any interested person and may direct, et cetera, et cetera. So our point about that particular sentence and the use of the words in that sentence is a letter rogatory has historically been understood to be an exercise of comity between governments. And in the context of the pre-1964 amendments, an exercise of comity between courts in foreign countries and courts in the United States. So a letter rogatory request sort of in and of itself is something that signifies a government-to-government transaction. And for that reason, when it refers to a letter rogatory issued or a request made by a foreign or international tribunal, that in itself suggests that the words foreign or international tribunal should suggest a body exercising government-conferred authority. To be sure, we certainly agree with petitioners that before 1964, the statute was more limited because it specifically referred to courts and the intention of Congress.
Can I stop you there though? Like, I mean, I think you may have some better arguments, but this doesn't seem like it's among them because the letters rogatory is separated from the request made by a foreign or international tribunal by the disjunctive or.
Your Honor, I disagree. I'm sorry.
You disagree there's an or there?
I disagree that the or separates foreign or international tribunal. I think that the words letter rogatory issued or request made are part and parcel. In fact, you can see commas. I think it's separated by commas, but I think what the statute is saying is a letter rogatory issued or a request made by a foreign or international tribunal. So those are two avenues by which a foreign or international tribunal can request assistance. And then you have the secondary avenue, which is completely separate and does not describe a request from an international tribunal. It says, or upon application of an interested person. So I would argue that the two things that we're looking at as avenues by which a foreign or international tribunal can request assistance are letter rogatory or request. And the way I would read that is everybody agrees that letter rogatory is an exercise in comity. And I would read the word request to be also a request from a governmental body, but one that maybe does not have the procedural formalities of a letter rogatory.
So you don't think an international private arbitration tribunal could issue a request?
No, Your Honor, not as it's written in the statute, because again, the proximity to the words letter rogatory suggests a government to government transaction.
Letter rogatory does, but request doesn't necessarily, and it's arguably there specifically to encompass requests that can't be done through letter rogatory.
Your Honor, I don't think that's the proper way to read the word request. I think, you know, in the canon of sort of understanding general, more general words in the context of specific words that they follow, it should be understood to be, again, a request between governmental actors, although perhaps less specific. And although I certainly don't agree with everything in Professor Smith's article, I would direct the court with respect to this particular question. If you look to page 157 of your record, this is from Professor Smith's 1965 article. So before he was sort of very much on the side of petitioners and more directly after the amendments were made. He's discussing 1781 says, the State Department's authority to process letters rogatory extends to requests not couched in documents formally designated as letters rogatory. The juxtaposition in the statutory language of letters rogatory and requests makes clear that every proper request, whether or not denominated or in the usual form of letters rogatory, may be processed. So that's essentially the way I'm reading this sentence. I think that's the best way to understand it, just based on the statutory text. And of
What
course,
about the practice and procedure language? You have some argument, I guess, that practice and procedure necessarily refers to a state-sponsored tribunal? I didn't quite get that.
That's right, Your Honor. I think insofar as the statute is referring to prescribing practices and procedures that follow what is used in foreign countries or by the international tribunal suggests an established practice by a foreign body, by a foreign country, or by a multilateral body. So just insofar as, you know, private arbitrations are determined by contract, and the rules are, of course, are agreed to by the parties, and they're going to vary by arbitration. So it's much more ad hoc. I think that, again, the language, the use of the nearly identical phrase in the fourth sentence also tilts in the direction of suggesting that Congress was concerned with foreign or international tribunals, meaning government-sponsored bodies. But again,
what's your response to the argument that international commercial arbitration, even private arbitration, is to some extent state-sponsored? I mean, it only exists and can be enforced by virtue of the New York Convention and national laws. And, you know, if there were some other kind of adjudicatory body that wasn't supported by the convention and national laws, maybe then, you know, that definitely wouldn't count, or might not count. But that, you know, in the context we're dealing with here, that there is some sort of state sponsorship.
well, again, I think that's sort of putting the cart before the horse. I mean, the project of determining what the statute meant is to look at the language Congress used in the context that it used it, and to assess sort of what was the intent there. And I think based on the language Congress used, clearly what they're going for, the expansion that they were going for, is quasi-judicial administrative type proceedings. So those, again, are bodies that are exercising government authority. And if I can just, I think Petitioner misconstrued our view a little bit. We're not in this, I don't think the question of whether bit arbitrations fall within Section 1782 is before the court. I think bit arbitrations are a gray area, a kind of difficult question that need not be resolved by the determination of whether entirely private commercial arbitrations are outside the statutory context. I think it's very apparent from the language Congress used that private commercial arbitrations that are purely creatures of contract are not what Congress had in mind.
Whatever we decide today will have significant implications for the next case that does raise a bit question.
Certainly, Your Honor. And I think obviously our view is that the statute does not cover private commercial arbitrations. And then, you know, assuming that the court agrees with that, the question of whether bit arbitrations are closer to the administrative quasi-judicial bodies that Congress clearly intended to capture or not is perhaps a question for the next case. I think there are good reasons why there are significant similarities. Certainly, these are creatures that are based on treaty, but they are also, the dispute resolution mechanism is one of contract. So there are reasons to say it's not really at the heart and soul of what Congress was trying to accomplish with Section 1782. In my view, the better reading of the statute is that those are out, but I think that's a more difficult question that the court need not address
It can't be that the contractual basis of jurisdiction is the thing that differentiates between what's a tribunal or not. I mean, you would say, I mean, if a court was hearing a case because the parties agreed to hear it there under a form selection clause, that would be totally fine, I assume.
Well, but in that circumstance, the jurisdiction of the court doesn't depend on the party's contract. The jurisdiction of the court is determined by various statutes, and the party's contract brings it within the jurisdiction of the court. That to me seems very different from the notion that the entire arbitral body is a creature of contract. And I think actually that's a very good way of sort of differentiating one from the other.
Well, it's a fair distinction, maybe. I'll let Justice Bookman decide that, but is it a fair distinction that has anything to do with the statutory text? I mean, you can't just duck the bit question. You got to tell me, what is the essential characteristic of an international tribunal?
In my view, Your Honor, the essential characteristic of an international tribunal is essentially a government body. It's something that looks like a court, something that I think in this country would be analogous to an agency proceeding, to probably not so analogous in this country, but clearly the Congress was trying to capture investigating magistrates, which, unlike in this country, are much more on the judicial side. So I think those things.
I'll grant you it wanted to capture magistrates, but I don't think it did that by saying international tribunal. I mean, Inspector Javert was still French, I think, not international. So the international must have been designed to capture some kind of multinational sort of entities.
Yes.
It seems like it would capture the bit things or some arbitration under, in The Hague or something that resolves some war claims.
Yes.
And so if it covers that, why doesn't it cover the private agreements? That's, to me, the key question.
I agree, Your Honor, and I would certainly agree with you that international does its own work and is speaking to the idea of a multilateral body, like you just suggested. But I think there's a sequencing of, again, so going to the sort of the heartland of the statute, and then where the questions get a bit harder. Certainly, the statute intended to capture multilateral bodies. In fact, the legislative history talks about international bodies of which the United States had agreed to their creation, right? So things like UN commissions, where the United States is part of the process for creating those types of bodies. Those bodies that resolve multilateral disputes, I think certainly is captured within the idea of international tribunal. Again, I think that the question of whether a bit type arbitration, which is created by treaty and has its basis in international law, falls within or without that heartland. But that is completely a separate question from whether a private international arbitration that is not connected in any way, it's not created by any body of international law, it's created by contract between the parties and by private actors, is necessarily covered. So I think—
I don't know if I can really make any of these policy determinations because I'm not Congress. So I just want to look at the language. And aside from that language we talked about the letters rogatory and the procedures before, I understand that you have a broader context-based argument that I think involves like other places in the U.S. Code about arbitral tribunals, and then also a comparison with the Federal Arbitration Act. Can you take me through that? Because I'm really interested in going back to the statutory text.
Sure, Your Honor. I think with respect to what's in the U.S. Code, yes, in our outline we talk about just the idea that generally when Congress intends to talk about arbitration, it uses the phrase arbitral, and that is throughout the code. I do think that the question of the FAA is really critical here. So as was discussed a bit with Petitioner, under Petitioner's reading, there's an indirect conflict with the FAA, and then there's a direct conflict. And both obviously suggest that Petitioner's reading is incorrect. So looking first to the sort of more indirect conflict, the broader conflict, as was discussed, Section 7 sets out specific and limited processes for getting discovery, for a private arbitral body getting discovery from a U.S. court. Only the arbitrator can ask for it. The district court is limited to geographically to within its own district. So very specific limiting things. So there's a real question as to why Congress that set out those limitations would 4 decades later decide to create a mechanism for a completely international, completely foreign arbitration to have much more access to discovery in US courts, why Congress would be solicitous of private arbitrations that exist abroad in a way that it was not with respect to domestic arbitration. So I think that's point one. Point two is you then end up with this category of arbitrations that there's a really direct conflict with the FAA, and that's those arbitrations that are seated in the United States but that have an international component and are therefore recognized under the New York Convention and then brought in the FAA through chapters 2 and 3. So for those arbitrations that are, again, seated in the United States but have some kind of international component, whether it be an international litigant or some other component that makes them international, they are covered by the FAA through chapters 2 and 3, which ratify the New York Convention, and subject to Section 7. So for those types of arbitrations, you then have two sets of rules. You have one set of rules that's very narrow and one set of rules that's much more broad. And obviously, to the extent that a party within one of those arbitrations wanted discovery, they would use the Section 1782 door. And I think there's real reason to question why Congress would have done that, particularly because the ratification of the FAA, the ratification of the New York Convention, and the amendments that included chapters 2 and 3 of the FAA occurred after Section 1782. So you have to ask the question, why then would Congress have decided that Section 7 should apply at all when discovery is available through a much broader mechanism? And I guess the one other point I would add is this is not a hypothetical conflict. We have this problem. We see this problem come up quite a bit, where these domestic seated arbitrations now try to claim access to 1782, and it sort of does create the conflict that the Second Circuit first identified back in the NBC case. So
I'm
again,
interested. Yeah, and I don't want to take away from the statutory point because I think that's an important one to drill down on. But I'm still interested, as you answer this question, on your answer to the question of why your take is more pro-arbitration, right? Because we've consistently interpreted the FAA in the way that we believe is the most pro-arbitration. So how is your approach consistent with that approach?
well, I think the words pro-arbitration are sort of, I think we're maybe using them in a slightly different context. I think the petitioner is using them in a way to say whatever participants to arbitrations want, they get. And I don't think that that's what the policy is. I think the policy is it favors arbitration insofar as it recognizes the choice that people made when they contracted to resolve a dispute through arbitration. And part of that contractual agreement was efficiency. It was avoiding massive litigation. It was avoiding the kinds of discovery that happens when you take a case to court. So I think what I would describe as a consistent policy in the FAA would be one that recognizes that private commercial arbitrations, whether they be out of the United States or in the United States, are not subject to the kind of discovery that you would have in court. And I think that's consistent with our perspective on what Section 1782 means. And just to add another point, I think it's been discussed a little bit, the idea that one of the aims of Section 1782 was to model for other countries. If that's true, then modeling for other countries would include other countries allowing US arbitrations to get discovery through their courts or through their processes. That is inconsistent with the way this court has interpreted the FAA and what's available under the FAA. So I think that's yet another reason why seeing these two statutes together and reading them harmoniously really weighs in favor of our perspective.
I guess one of the questions I have is whether petitioner's position really would be all that bad. Because like I could see a concern about floodgates, but we'd be giving so much discretion to the district courts. So it really seems to me like the district courts could be the gatekeepers here. So why isn't that kind of a solution?
I see I'm out of time, but if it's okay with Mr. Chief Justice, I'll answer the question. I think that's the fact that it might not be so bad is not the right way to determine how the statute should be read. The right way to determine how the statute should be read should be to look to the text, to look to, if necessary, if there's ambiguity, to the legislative history and to what Congress was trying to accomplish here. But even if that's not persuasive to you, I guess I would add one more thing, which is what this allows, even if, as my friend on the other side said, sure, arbitrations overseas can say, I don't care about your evidence, I don't want it. But what they can't say is, you're not allowed to ask for it, litigant. Any litigant can, without the permission of the arbitral tribunal to which they are bound, go to the United States to try to sort of dig up evidence. And I think that alone is problematic, even if the district court denies it, and even if ultimately the arbitral panel doesn't want it.
Thank you, counsel.
Thank
We'll
you.
now hear from Amiki.
Thank you very much. May it please the court. My name is Ari McKinnon. I'm appearing on behalf of the amicus professors against the petition. I want to speak to the public policy implications of adopting the petitioner's expansive construction of Section 1782. The petitioner's position is not pro-arbitration. Extending Section 1782 to cover foreign commercial arbitrations would have profound negative implications for the practice of international commercial arbitration. The discovery practice embodied in Section 1782 has no analog in many foreign jurisdictions. Moreover, to the extent that any discovery is available in those foreign jurisdictions, a key reason why parties choose to arbitrate their disputes is to streamline the resolution of those disputes and avoid costly discovery, as well as other procedural formalities attendant upon courtroom litigation. Therefore, in recognition of the deliberate choice that the parties have made in opting for an efficient and less costly dispute resolution mechanism, Section 1782 should not be read to extend to foreign commercial arbitrations. Now, while petitioner claims that this result would somehow penalize litigants for choosing arbitration, the result in fact recognizes and gives effect to the fundamental principle of party autonomy, which is at the heart of long-standing U.S. law regarding arbitration. And the result also honors the contracting parties' well-founded expectations upon entering into an agreement to arbitrate their disputes outside of the United States.
Can I just test that? I mean, if this is all about party autonomy, I mean, suppose, the parties to an international arbitration agree that, all questions about the scope of discovery will be for the arbitral panel, and the arbitral panel then decides, we want to enlist some help from U.S. courts through 1782. As I understand your position, you wouldn't let that happen. And the other side would say, yeah, we'll let that happen. And the district courts will probably, deny most of the other stuff.
As a practical matter, a fundamental principle of international commercial arbitration practice is the principle of limited discovery. There may be some exchange of information, but that discovery, to the extent it occurs, is at the discretion of the arbitration panel. That's what
Sure. But in my hypo, the arbitral panel agrees with you 100%. They say just a wee bit of discovery. But the key piece of discovery here is lying over in America in some third party, box. And we don't really have a great way to get it over here. So we're gonna use 1782. Why would that be inconsistent with the aims of international arbitration or the autonomy of the parties who, after all, agreed to kick questions about the scope of discovery to the arbitral panel?
No, as a practical matter, one of the key things the parties decide when they negotiate their arbitration agreement is where to seek that arbitration. And therefore, in so doing, which national courts are going to have some supervisory authority over the arbitration process. When parties decide to seek their arbitrations outside of the United States, they are deciding quite consciously, this is a very heavily negotiated issue, they're deciding quite consciously that it will be the national courts of another state, the foreign state, that will exercise whatever limited supervisory authority courts are permitted to exercise. So in that,
I guess that depends whether you're right or wrong about the scope of 1782, right? Because they either make that decision against the backdrop that, yeah, we're going to go over in Switzerland, but we always have the opportunity to potentially get something out of the United States, or maybe they don't, but that's kind of the ultimate question here, right?
yeah, parties have been negotiating arbitration agreements against the backdrop of Section 1782 basically not being available to private commercial arbitrations for many, many years. We do have two recent circuit court opinions that have gone the other way. But as far as parties' expectations in the international arbitration community for private foreign arbitration, Section 1782 basically has not been available. So when they're contracting and deciding, we're going to have, in your example, the Swiss courts exercise supervisory authority, they're expecting that to the extent they wind up in a court somewhere, for some reason, it's going to be a Swiss court for limited purposes, unless we're on the back end and we're talking about enforcing the arbitration award under the New York Convention, as the case may be, in which case they may come to the United States for the very limited purpose of enforcement of the award under the New York
Can I
Convention.
just ask you a specific question? Because I really have a hard time trying to figure out like what's good for arbitration or what's good for the parties in the abstract. Like, tell me this, if we accept petitioner's position, what bad things are going to happen? Just as concretely as possible, tell me what would be bad about that, giving that discretion to the district.
We will have a rash of 1782 ancillary discovery-related disputes under Section 1782 in the United States, which will force parties that have agreed to arbitrate their disputes outside the U.S. to hire U.S. counsel to come and litigate those disputes here in the United States, which will make the process of arbitration less efficient. Obviously, it will also make the process more costly, more time-consuming. And regardless of whether the petition is ultimately granted. So the petitioner's view is we can let the district courts decide this. They have discretion, they can exercise that discretion intelligently. Regardless of whether the petition is granted, we're going to see significant delays in the arbitration process. And we're going to put foreign parties who have opted for a foreign seated arbitration at a significant disadvantage to have to come into the U.S. When their dispute has no tie to the U.S. To litigate discovery-related issues that in all likelihood are very much foreign to the way that they do business on a regular basis, and also to arbitration practice. That will have a negative impact on the efficiency of arbitration and in terms of time and cost.
Is it going to have any?
Arguably,
Oh, go ahead.
no, I was just. Isn't that what if Congress is expanding discovery and allowing it for foreign and international tribunals? Isn't that? I mean, even if it's not, maybe even if it ends up with this, maybe bad result, isn't that what Congress wanted?
I think that, Justice Bookman, you've a number of times gone to the basic pro-arbitration policy that's embedded in the FAA and throughout federal law. So I think Congress has demonstrated a special kind of concern for international arbitration, that it maintain its basic kind of characteristics of being an efficient way to resolve disputes. And so I think in this particular case, although 1782 can obviously be used as an aid in terms of foreign courtroom litigation, in the case of arbitration, I think Congress has made very clear we don't want to intervene in the internal kind of workings or procedure of the international or the arbitration process. And we want that process to remain a viable, efficient alternative to litigation.
And can I just, my quick follow-up was just when you were articulating the sort of policy concerns, what I didn't hear, and I'm just wondering if it's because, you already had a long list and you got to stop somewhere, or whether it's because this isn't actually true. I just wonder, does this have sort of an asymmetric effect on US-based companies, that they're just going to be sort of asked for information in cases that they're not even a party to? Is there any kind of hassle effect for US companies? Or is that not really true?
I think there's a huge hassle effect for U.S. companies. 1782 is directed principally to third parties, as the amicus for petitioner has indicated. We're talking about investment banks, consultants, advisors, accountants, and the like, many of whom have offices, not surprisingly, in the United States. Even if those consultants, investment banks, and the like have advised on deals outside of the United States, you're going to have kind of disgruntled parties in arbitrations coming to the U.S., serving Section 1782 requests on those consultants, investment banks, and the like here in the United States, and then trying to piggyback on certain rulings on the availability of worldwide discovery to try to get discovery from those entities, from their offices abroad. I think the U.S. is a country that is going to be, and its U.S. companies are going to be particularly targeted by Section 1782, just because we have so many of the investment banks and consultants and accountants which have offices here in the U.S. I think my time has come to a close. Unless there are any further questions, I'd be happy to turn the floor back over to petitioner.
Yeah, we appreciate the presentation, and I think we have a few minutes left for petitioner's rebuttal.
Thank you, Mr. Chief Justice. I wanted to come to Justice Saharsky's question about if setting aside all of the policy implications, how do we best understand this text? What does it tell us? And the simplest and most straightforward way to understand this text is to say that 1782 applies to tribunals that are either foreign or international. There's, as I understand it, no significant dispute about what a tribunal is. It's an adjudicating body. The question is, whether foreign or international, as my friend on the other side suggests, really means foreign governmental tribunal or international governmental tribunal, or just means foreign tribunal or international tribunal. And I think there's really no contest.
Can I just stop you there? I mean, isn't there a pretty good argument that international means like international? I mean, when we talk about international organizations, I think of like the UN and, you know, those kind of international organizations. I don't think about like, you know, some company that spans like, you know, this, you know, the Spanish-Andorran border, and that's an international organization. I mean, and isn't it a pretty natural reading of international tribunal that it's the same way?
Well, certainly, I think it encompasses. I think Your Honor mentioned the Hague proceedings and the like. I wouldn't think there'd be any doubt it encompasses that. But the New York Convention also distinguishes between, you know, domestic and non-domestic disputes and treats disputes that have an international character. They're between parties from different countries, where foreign law provides the underlying basis for resolution as being non-domestic. And I think that's the nature in which Congress was thinking about international when it talked about international tribunals and international dispute resolution against the backdrop of an explosion in international commerce in the 1950s and 60s. So I think that's the nature of the character. But in any event, the respondent's argument turns on something, you know, much broader than the nuances of how to understand international. For their position to be right, governmental has to be there, and there's just no footing in the statute to say that governmental qualifies the kind of tribunal that for which aid under 1782.
What about the broader context, though? You know, the broader context, you've got the references to letters rogatory and the like, but then you've got a real contrast with the FAA, it seems like. It just seems like the broader statutory context might put some limits on this.
And the timing.
And the timing?
Just in 1964, what they would have been thinking of.
Understood. So let me address the FAA point first. I really don't think there's a conflict here, and that the courts that have suggested otherwise have made something of a category error. A statute that, if there are two statutes, each of which a district court can turn to and has permissive authority under to provide discovery aid, there's no conflict if one is broader than the other. It's just that there are two statutes to which the district court can turn. It's a little bit like how Rule 16 of the Federal Rules of Criminal Procedure provide discovery to a criminal defendant. And then FOIA also is available to any person to seek records from the government. The argument was been made, but then resoundingly rejected by the courts of appeals, that FOIA can't operate where criminal discovery operates because there's a conflict. They said there's no conflict, there are two statutes. And that's exactly what's going on here. There may, in some circumstances, and it's a minor slice of this puzzle, be two statutes to which a person could look in applying to a district court for aid. And under either, the district court can consider whether to grant the aid requested as against the background of the proceeding. To me, that's not a conflict. That's a place where Congress has written two statutes, and each should be allowed to operate in its own scope. As for 1781, I think the Chief Justice's question was precisely right. That the statute refers to letters rogatory or to requests made, and a request is simply something different than a letter rogatory. So I don't think that sheds light on what an international tribunal can or cannot be. To me, all this sort of echoes what happened in the Intel decision, where the parties were suggesting, well, actually, an interested person has to be limited to litigant because there's a reference to service, and only a litigant needs to be served. So you see, interested party must mean a litigant. And the court said, no, interested party means interested party. And here too, tribunal means tribunal, and the presence of references to letters rogatory and the like in the vicinity of foreign or international tribunal just doesn't shed light on the meaning of that phrase. The other point that I thought might be worth addressing is the practice or procedure point as to what the district court can grant. Again, I think that this is sort of a false friend in statutory interpretation. What 1782 indicates is that there's a default rule that the federal rules of civil procedure apply, that the district court may order something else, and that in considering what else to order by way of procedures may look to foreign law. That's just on the laundry. It's all of that is just emphasizing the district court's discretion to make a discovery order fit for the proceeding before the court, if any discovery aid is to be granted at all. If there are no further questions, I will rest there.
Thank you, counsel. The case is submitted. And if I understand our order of proceedings, I mean, Benno, do you want to tell us what to do?
I think what you were going to say. I think what you were going to say is, well, let me say this first. If we were in the same room together, there would be an outpouring of applause for what the advocates have done. They were. I know you all will say it yourselves, but I thought they were marvelous, and they've been marvelous to work with. And working with them meant putting together two very detailed outlines of their respective positions during a time period when they were all arguing lots of other cases and doing many other things. So I think you all did a great job, and we're really grateful. So our applause, our hats off to you for what you've done. The second segment is really to hear from the tribunal and from counsel. I think starting off with the tribunal, your thoughts on what arguments do you think are going to resonate for the court if this issue gets there, which there's certainly a conflict for sure. And we're interested in your perspectives, having heard the arguments and read the cases.
So, I mean, thanks. I think, you sort of stole my thunder on the first order of business, which was I was just going to, thank the counsel in a way that the real Supreme Court doesn't. But you guys were absolutely terrific, and I think there are challenging aspects of both sides of this case, and I'd like to think that you were challenged, but you all did a terrific job. So really, really appreciate it, and I think it really helped elucidate the issues. I have some thoughts on this, but maybe I'll let my co-panelists go first, and I'll take the Chief's prerogative to vote last. Nicole, do you want to kick us off, or?
Yes, sure, happy to. So first of all, I thought everyone was terrific. I mean, really wonderful arguments. I wish that you all worked with me at my law firm because it would make my job so much more fun, but I haven't managed to persuade Martine, so I probably won't manage to persuade the rest of you. Anyway, so I thought the arguments were pretty just evenly balanced in terms of the arguments that are out there. And I do think that the arguments that we aired are, through the discussion, are the kinds of things the Supreme Court will care about. I mean, obviously, first of all, starting with the text, which I think the international or foreign or international tribunal by itself does seem, fairly ambiguous. Tribunal is broad, but then you've got this context in which it appears, and it does make, a judge or justice wonder, well, is letters rogatory limiting? Is the practice or procedure limiting? And then to look like you all did to the broader statutory context, is there a conflict with the FAA? What about the other provisions of the U.S. Code? I mean, I was very interested, and I thought the outlines did a terrific job of handling this. How does Congress use language like this? Do we think that this, based on what other things Congress had done, is broad language or is it narrow language? And then, we asked some questions about, well, what did we think Congress was trying to do in 1964? It was trying to make a change. Was it a broad change or was it a really broad change? And then, I think the court typically asks, and so we tried to ask some questions about kind of practical effects in terms of, would it be so bad to give the district courts this discretion, et cetera, et cetera. So I guess just as a starting point, maybe I'll just say this and stop there. I thought the questions to me pretty well reflected the kinds of things that would be on the justice's mind, which would be, quite text-based, but also a lot of like, does this make sense? And what does this really mean? Practical implications.
Yeah, I totally agree with all of that, starting with how terrific everyone, all the counsel did. It does seem like the statutory interpretation question is at the heart of all of this. And I would only add that I think the intersection with the FAA is something that would interest the justices a lot in trying to figure it out. And I do think that the the question about bits and how how other kinds of arbitration might fit into this scheme is a really interesting one that I don't know if they can totally disaggregate from answering this question. They may try. I'm not sure.
Yeah, and so I'll give my perspective on this, which in addition to thinking you all did a terrific job, I think part of the reason you all did a terrific job is because you're terrific. Part of the reason you all did a terrific job is, this is a close and difficult case. There's a reason the circuits are split, and and to me it fits like a classic pattern of Supreme Court statutory construction cases. Whereas, I think one side's got a better textual argument, or at least a more straightforward one. And then the other side has, kind of a better argument about what Congress probably actually had in mind in 1964. And, in some respects, it's easier to say, it's almost, it's probably easier to write the brief for just the plain text side. I can see the brief now, right? It says, the statutory construction begins with the text, and when the text is clear, it ends there as well. And then you cite like 50 cases that say that, and you're already 4 pages into your brief. It's great. So that's probably the easier brief to write, but it is, it can be a difficult argument. And I thought petitioners did a great job, but it's. It's a difficult argument because there are a lot of things once you get past we're right on the text, the plain text, that don't make a heck of a lot of sense. I don't know really why, if Congress had really thought about it, that it would have adopted a different rule for international arbitrations than for domestic arbitrations and what they did in the FAA. And for some justices, it's going to be enough to say, who cares? They didn't think about it, but the text is the text is the text is the text, and we win. But for other justices, and I still think it's probably, more than half the court, it's not enough to just say, who cares? You have to have kind of an explanation. I thought you offered some pretty clever explanations to what seems to me like an awfully difficult argument. On the other side, you have, I think, a harder brief to write and in some respects, harder judgment calls. Because if you're arguing for the petitioners in this case, like it's pretty easy to understand that like what you do is, you do the best job you can and then you bring the court back to the text. And, and that works pretty well. Harder if you're an amici for the petitioner, because then you're supposed to be talking about things other than just the text, but still, that's still the pretty obvious right call. Whereas if you're arguing kind of the respondent side of this and you need to kind of keep on kind of feathering in different arguments that, without conceding the text, that, still get the court to focus about something else. And then you have to have a sense of kind of how well they're going. And I think that's, that's tough. I mean, for me, I did get distracted in the letters rogatory argument because I look at this or requests and that seems like it's broader. Whereas, to me, the FAA Section 7 argument resonates a little more. But boy, that's tougher. And I think it's tougher too for that side of the argument because it's not 100% obvious what your sort of, point of to return back to your home bases. I think in that sense, I think it's maybe a trickier argument because I think it's a winnable argument as demonstrated by the fact that that position has prevailed, I think in more circuits than it hasn't. So I think it's a winnable argument, but it's a challenging argument, especially in a Supreme Court that, at least some justices are going to be grumpy if you talk about the legislative history. So, and I will say, from the respondent's perspective, rather from the petitioner's perspective, I do think the place to be on that side of the argument is the text. And, maybe you talk about the law review article in your brief, but I think because I do think that to the extent the law review article kind of revived this issue, which seems chronologically to sort of maybe be right. I don't know, but I don't think it's like I can see some justices just going berserk if somebody tried to say that a law review article, and so, with all due respect to the law professors, but there are certain justices, if they hear an advocate saying they're not just relying on legislative history, but sort of private legislative history in a law review article written by the reporter, they are going to lose their minds, and at your expense as the advocate. So just that, which is frankly another thing that's kind of interesting about this case, because I do think at some level that's relevant, but I think it would be a hard thing to use in a Supreme Court argument. And I guess the last thing I'll say is, who knows? They're almost certainly going to grant this case at some point. Who knows when? If it's granted at a point where they're arguing cases in their sequential order of battle, the way they're doing it now, where the justices kind of take turns asking questions, it would be a lot easier to rely on the legislative history or the law review article. You just wait to a justice that looks at that stuff to ask you a question, and then you quick sneak it in. But if you were doing this in a more traditional oral argument format, where if you say the words legislative history, Justice Gorsuch will ask you the next question. Then it's, I think, a more difficult kind of dynamic. So it's a great case. I mean, it really is from the non-arbitration specialist perspective. It's a great case just because it illustrates kind of the classic sort of text versus context dilemmas and has a few extra bells and whistles. So it'll be a really fun case to watch when the Supreme Court actually takes it.
Yeah, just to pick up on one thing Paul said, because we all said that you did a great job, but just to make that as concrete as possible. No. One thing that I think is generally true in the Supreme Court, but definitely would be true in this case, is that, both sides need to have a position that hangs together, like a holistic position, right? It can't just be all text for petitioners. It can't just be all like, purpose type or legislative history or whatever for respondents, right? And I think that one of the things that I really enjoyed just from my perspective and watching you all as advocates is that you all realized that, you needed to come with kind of like the whole story that all hangs together and makes sense, and you have an explanation for how it makes sense. And not all advocates do that. So from my perspective, that made this a really enjoyable argument, because you all had thought about kind of all those tangents, and you weren't one trick ponies. You were all like many trick ponies.
Do any of the advocates have any thoughts they want to share with the audience or with the tribunal about this experience, this case, this statute?
So I certainly tried not to be a one-trick pony, but at points in trying to pull this together, it felt like there were many bucking broncos. I really do think that this is a really hard and delicate set of arguments, and just from the petitioner's perspective, I think one thing I tried to worry about and think about was how to not make the argument too shallow. Like, okay, tribunal. Now what? Like, what are my other actual moves if that one's not selling? And Paul, I think to your point, in some ways there's more different levels and depth to the natural respondent's position, and trying to sort of meet that was really challenging. Also trying to figure out what to do with this law review article, because look, if Justice Ginsburg hadn't built her whole opinion around it, there's no chance I would have said anything at the argument. Maybe it would have featured minorly in the brief, but in the argument, never say anything about it. And I think I would have tested out in a moot like this. Do I raise it at all? Do I try to put it entirely in Justice Ginsburg's words, even though the line that's best for me is not in the Supreme Court opinion? What exactly do I do with this gift that wasn't given fully wrapped? So I think those were some of the challenges, and then just thinking about, I stand by my position. I don't really think there's a conflict, but there is a real oddity in trying to think about, well, especially once you say, as I think I felt drawn to at the end of the day that international includes all the New York Convention kinds of cases. And so also, arbitration sitting in New York next door, like figuratively to the AAA arbitrations, that there should be some, different treatment. I think that's a hard place to, a hard thing to push all the way across the line. So lots of challenges, really interesting. And thank you to the panel for pushing us, and also to my friends, not figuratively, literally on the other side for their awesome advocacy. It was really fun to try and engage with.
Yeah, I fully agree. And I would also say thanks for the compliments. It's nice to get them once in a while because typically obviously don't. So much appreciated, especially from all of you. I fully agree with everything everyone's been saying. There's nuances in this case that make both sides really challenging. And I think from my perspective, my first reaction when I got this was, especially with the NBC case being the pull on one side, and it having been decided in the late 90s, kind of before the court moved to much more of a pure textualist view. And with that case sort of being the leading case on our side, like, ooh, that's not a move analysis that's going to really impress anyone in this Supreme Court. So trying to create more of a textualist argument, which I think there is one, but sort of doing it a little bit out of whole cloth and not sort of having just a great underlying decision to say, the court below is right for all these reasons. So that I found to be a bit of a challenge. And certainly, as Justice Clement was saying about the question about judgment calls, from my perspective of what do you do with the BIT cases, assuming that this comes up in a very, pure sort of private arbitration context, it's not a BIT case. I think for the respondent or the petitioner, whichever side it is, where does BIT fall on the spectrum is, to me, the most challenging aspect of this.
One thing that made this case way easier from the petitioner side is that I didn't have to worry about like an actual request that would be going back to the district court and trying to defend that. So I could kind of be maximalist. The district judges will shut down all the bad things and leave only the good things without having to actually worry about whether my thing was bad or good. So I think that would be a complicating factor for someone actually arguing my position.
One of the questions that came in from the audience was one that the court asked a couple of times, and I think Justice Bookman asked it more regularly, and that is, what's the pro-arbitration position in this case, and is there one? Because we've often had this debate, and I know Professor Berman in particular has weighed in on this. What does it mean to say something is pro-arbitration? There are really different views about that, so I'm really interested in sort of, I guess, the panel's view on that point in particular.
I mean, I'll take that on. I mean, the way I read the court's decisions in the FAA when they talk about what they mean recently, cases like Epic or Lamps Plus, when they talk about what they mean by pro-arbitration, they're often differentiating arbitration from litigation. And we heard some of these arguments saying that, when you opt into arbitration, you're opting into something that doesn't look a lot like litigation. And it's important when we, enforce the FAA, the court says repeatedly, to maintain those distinctions. And I think this is a place where they could sort of build on that line of reasoning and say, if you allow, U.S. style discovery in international arbitration in these kinds of ways, then that goes against our view of, the way we see pro-arbitration FAA as maintaining these distinctions between litigation and arbitration. I mean, I've written about why I think that's the wrong way of approaching the question of what is pro-arbitration, and I'm sure people listening now have lots of thoughts about whether that's the proper definition of pro-arbitration, but I think there's rich support for it in the court's decisions. Curious what others think.
I frankly had a hard time figuring out what really is pro-arbitration in this context, because like you said, it's not the typical litigation versus arbitration. It's more like who can do this, and clearly some people can do it. So it's just a question of how broad it goes, which is why frankly, I kind of gave up and asked the questions that were more like, tell me the bad things that will happen with each side's position, because pro-arbitration, it just seemed too abstract for me.
Yeah, and I have a similar take in the sense that I think classically when the court talks about that, it is talking about arbitration versus litigation. And so it doesn't map on super well. And I do think that if the petitioner's position here tried to kind of do too much with that, you know, they would get kind of the kind of resistance that I offered at one point, which is just, it's a funny kind of pro-arbitration that says that you really, really, really need the help from the courts. You know, that just seems contrary to at least where I think you know, a lot of the justices that have signed on to lots of pro-arbitration opinions, that's not where they're coming from. The other thing that makes it just, you know, the one place where I could see that maybe coming up is, you know, if you sort of, I mean, one way you could try to sort of characterize what the respondent's position is, you know, and Nicole tried this a little bit, which is, you know, you try to sort of get the respondents to more or less concede that, you know, international tribunal is at least ambiguous. And then I think you could argue that if you then almost like apply like a quasi clear statement rule that unless they say arbitration, it's out, I think you could try to label that as, you know, reflecting kind of hostility to arbitration, which is, you know, sort of the flip side of the pro-arbitration rule. So that might be the one place where you could try to sort of sneak that in. But the other problem with the petitioners trying to go too far with labeling themselves pro-arbitration is that, you know, the context in which the court keeps on saying that you got to be pro-arbitration is the FAA. And the FAA seems like it's much more respondents' territories than petitioners' territory here. Because, you know, again, I could be wrong, but I think, you know, the biggest challenge for petitioners at the end of the day is, you know, Section 7 of the FAA. That just, you know, that does seem to reflect a pretty sensible way of dealing with this issue by a Congress that actually focused on the issue. And the idea that a Congress that pretty palpably did not focus on the issue came up with a rule that makes it much, much easier to get into district court. That, you know, that seems to me to be probably the single biggest headwind to adopting the petitioner's position.
Okay, well, I think, you know, one thing about the advocates, boy, everyone really stayed on time. This is really, I've never seen time so marvelously managed in my life. Before we close, I just want to be sure that everyone, there have been a couple of questions on the chat about CLE. And if there are any questions about CLE, if you could please email the following email address. It's lawcle, all capital letters, lawcle@fordham.edu. And our colleagues there will provide whatever you need with respect to the CLE information. And again, the forms are all on the link that was sent to you last night, and so that they're available. I really want to thank all the members of this panel, the mock justices, the advocates. I mean, this really was special, and I think everyone really enjoyed all the hard work that you put into this and the perspective that you've given us on how the court, many of whose members may not know all that much about international arbitration, might look at these issues. And that's really incredibly valuable, I think, to those of us who practice this every day. So thank you so much. Thanks so much to the audience. This concludes panel 2. There's one more event today, and that's, you need to register for that separately too, but at 5 o'clock, there's a closing for the Fordham conference, but it's also the closing for New York Arbitration Week, and we hope as many of you can attend that as possible. We've really enjoyed this, and again, thanks so much to the panelists and to the tribunal. We're really grateful.
Thank you all.
Take care, everybody.
Thank you. Bye.
Thank you.
Bye.